Hi, everyone. Well, I'll try to be very brief. I can talk for hours, but I don't have the time. So I'm going to talk with you today about the Israeli new law that has been successful in achieving significant reduction of adverse litigation in family conflicts by almost 50%, demonstrating that social change is possible. As the minister talked before, the damaging impact of litigation and the understanding that family relationship persist beyond divorce has led policymakers in Israel to encourage parents to settle disputes without resorting to the legal system. However, encouraging is not enough. It was clear that a significant legislative change had to be made so that people would not run to court as their first and only option. The culture of debate is deeply embedded in the Israeli society, which may help to explain the overly adversarial approach to legal disputes, making it challenging to shift towards alternative methods of conflict resolution. So I will tell you about what we did with that law, which I'm glad to say that I had the opportunity to be part of the thinking and writing team that led to this new Israeli law. I translated the law to English myself because the Israeli government doesn't do that, so I translated the name to Regulating Legal Procedures in Family Conflict Law. The aim of this law, as mentioned in Section 1 of the law, is to help spouses and parents and their children to resolve family conflicts among themselves consciously and peacefully, and to reduce the need for conducting legal proceedings in consideration of all aspects of the conflict and best interests of each and every child. As Ian said before, it's all about the children. This new law is essentially procedural law that changed the default of the public. Instead of opening the legal process in family matters by filing a lawsuit, as was the legal situation in Israel before, with the entry into force of this new law, preliminary procedures were added before filing lawsuit in family matters. The new law created new procedures for state-funded pre-legal proceedings, as mentioned in the explanatory note, and I won't read it out loud, I'll just go through the stages. Okay, so the first stage of this procedure is, okay, I'll say it like this. Anyone wishing to file a motion on any aspects of family conflicts first must submit a petition for dispute resolution. I call it a motion to settle. The motion does not include arguments or facts relating to this conflict. The petition forms only require identifying details about the individual concern, which is intended to preclude any details about the conflict in order to establish optimal condition for the dispute resolution procedure. After that, the next stage is called a stay of proceeding, a period of 60 days during which the parties are not allowed to initiate any legal proceedings. They are prevented from filing lawsuit against each other, and the state forces the parties to stop and think before running to file a lawsuit. During this period, the parties meet with a social worker, again, a funded structure by the state. In this meeting, no lawyers are allowed in, only the parties with a social worker. And they're giving information about the implication of the legal proceedings on them and their children, on other ways to resolve family conflicts outside the court, and coping with difficulties arising from family conflicts. Well, this gives an option for the parties to meet and talk together without legal proceedings in the background, with the help of a professional mediator, a social worker, from the court without representative lawyer in the room. This is an exploratory meeting which is meant to examine and evaluate the possibility of negotiations. This setup is meant to give them hope about the feasibility of dialogue as the necessary stage for reaching a future agreement. And this law has been a huge success. Thank you.